Welcome to the Lusophone Arbitration Talks, the dawn of Lusophone arbitration, hosted by Mayor Brown and 3 Verlaine Buildings as part of the London International Disputes Week, or as we call it, the LIDW. LIDW is a collaborative representative body that demonstrates the global reach of the UK's dispute resolution community. I would like to thank Mayor Brown for partnering up with us at 3 Verlaine Buildings to make this event possible. Today, I'll be introducing to you some very important players in the international arbitration field. And they all have something in common, which is the Portuguese heritage, which translates not only in language, although we all work predominantly in English, but also in a legal culture that has shaped international law in many ways, but also evolved with it. There are many others that could be here representing the same sentiment. Colleagues from Latin America, Africa, and Europe, who are now leading arbitrators and practitioners in their home jurisdictions and elsewhere. Hopefully, this event will trigger a wider sense of community, and we can follow up with more discussions and getting to know more and more people from all Portuguese-speaking countries. So without further ado, I would like to introduce our moderator. It's Luisa Boim. Luis was the very first Brazilian I met here in London doing arbitration. He's been at Freshfields, then White & Case, and now is a partner at Mayor Brown London. Then we have Ana Serra Moura, the Deputy Secretary General of the ICC International Court of Arbitration. I remember seeing Ana listed at some events when I started working in arbitration. And I'm not saying that Ana is old or anything. I started old in arbitration. It's my fault. And I was thinking, Ana Serra Moura, there must be some connection with here. And it was, and I'm very happy that she accepted our invitation to be here today. And maybe she will be able to share with us not just her personal experience, but also the institutional perspective on all of this. Secondly, we have Frederico Singharajan, who is a barrister and arbitrator at Hardwicke, an important barristers chambers here in London. And Frederico has a very interesting profile because he was raised and trained here in the UK, but keeps a strong link with Brazil, where he was born, and with Latin American in general. I think he's very English from my perspective, and don't get me wrong, that's not a bad thing, but I believe he's now at that sweet spot in which he has a common law background, but also a deep knowledge of other legal systems, which position him to be among some of the best arbitrators I have worked with so far. Then we have Itueva Nogueira. She's a partner at Dentons LEAD. Itueva is a leading arbitration practitioner based in Luanda, Angola, one of the jurisdictions that made the most remarkable advances in international arbitration in recent times. Itueva is also an executive director of the UK-Angola Chamber of Commerce. We're very happy to have Itueva here this evening. Finally, we had to bring someone from Brazil, although I'm not sure if that was necessary, but maybe, and among so many choices, we decided to invite Guilherme Riso Amaral, partner at Souto, Correa Advogados in Brazil. Souto Correa experimented a remarkable growth in recent times, which is representative of the development of the arbitration in that country. And as a personal thing with Guilherme, I remember when he was a visiting scholar at Queen Mary University of London, where I teach international arbitration nowadays. But at that time, I was just taking my LLM, and some students would refer to him as, and I quote that, Guilherme, because I managed to find that in my WhatsApp, that guy who comes into class and challenges everything that the professor says and turns everything into a debate. So I hope he does the same here today. That's not a bad thing. And after that, he published a very interesting book on judicial precedent and arbitration. And we observe his career as a counsel and arbitrator with great interest here from London. So Luis, I'll give you the floor now, but I need to start by putting forward the difficult, I think, in my opinion, difficult question. Why it's important for us to be here today, discussing arbitration related to Portuguese-speaking countries. Why is this any relevant? Can you tell us why?
Thank you, Carlos. I echo your comments, and I would just only add that I admire all the speakers a lot. You're all brave. You're challenging, the status quo. You're coming out to play in a different field, and none of you have taken the easy route. So well done to you all. But turning to the market itself, I think there are 4 reasons why we're here today. One is the dramatic growth of disputes, both investment and commercial, involving investments in and businesses in Lusophone jurisdictions and Portuguese-speaking jurisdictions. And Anna will set the scene for us today with some of the statistics of the ICC, which are very valuable in measuring activity on those jurisdictions. And then there is this, perception that you have Brazil as a success case for that, and Guilherme here will explain to us, how after 25 years, Brazil is an adult in the world of arbitration, with adult problems and adult issues to get resolved. And then obviously this sets a good precedent for Africa, and whoever here has been doing an amazing job in Luanda, and we have colleagues here also in Mozambique doing a lot of good work, and you can see those jurisdictions flourishing. And I could not, conclude this introduction without mentioning Frederico, which is, the Brazilian barrister, who is again, and you, Carlos, as well. I mean, in chambers. And Frederico is obviously one of the first and the best known barrister for Portuguese-speaking jurisdictions in London. And just to conclude, we have London is it is a hub. It has proved itself to be a friendly jurisdiction that welcomes a vast range of professionals from all different diverse backgrounds that we see in this screen. So it's been an amazing path so far. So without taking much longer, I'd like to hand over to Anna, who's going to set the scene a bit for us of all this growth. Thank you.
Thank you so much, Luis. Good morning and good afternoon, everyone. It's a pleasure to spend the next hour with you, and many thanks to Luis and Carlos for the kind invite. I may have to regret that first, we will not be in a position to have a glass of champagne in London today, and the second, that this panel is not in Portuguese, but it's in English, but I understand the importance of doing it during this important week for London. Luisa, when I was, and Carlos, I was listening to you and I was thinking, I joined the ICC 10 years ago in a team that is currently the Latin American team. And back in time, we used to say already, if we would be lucky, we would mention already Latin American and Iberian team. And that was the first time, and I see Gustavo Schaeffer connected, who was deputy counsel with me at the time, that the ICC hired 2 Portuguese speakers at the same time in the same team, already recognizing the importance of Brazil in that time for the ICC. And it was already a fight for me to say this is not only the Latin American and Iberian team, this is also the Lusophone team, because we also have African Portuguese countries. So a lot has changed, and I think the purpose of our discussion today is to discuss what has changed over the past years. Here, just to begin with, last year, as we all know, it has been an extremely challenging year for all of us, and for, of course, the ICC as well. In light of the pandemic, we believe that we had an increase in the number of cases. And as you can see here, we had a record number of 963 if we don't consider 2016, in which we had a cluster of cases. I always think that it's also quite nice to see visually how we see the parties worldwide, and that's what we see in this slide. And here you start probably having some questions, right? You see Latin America being one of the most important regions for the ICC. And of course, here Brazil plays a very important role, accounting for 40% of that region. And we will see more in details the data for Portuguese-speaking countries. And then we wonder why Africa is still lagging behind. And we see a total of around 7% of parties coming out from the continent. And we will have, I'm sure, an interesting debate on the reasons for that. And also probably on if that really reflects the reality in terms of transactions in the continent. Here below, you can see just an important thing that I think it's important in the context of Lusophone arbitration is that 20% over the past 2 years of ICC arbitrations involved states and state-owned entities. And this is something that we have in common to all Portuguese-speaking countries. From Brazil to Angola, Mozambique, and even Portugal, we see an important number of states and state entities involved. Here we see the parties' nationalities, and with no surprises, with Brazil ranking first in the group. And it has been an amazing trip with Brazil, I think. And we see the steady increase of Brazil, and last year it was the second in the worldwide ranking, which it's a reason for all of us to be very proud of. And also the efforts that the ICC has been doing in the region. But not less important, I'm extremely proud for the increase in Portugal, which is last year represented almost 50%. So it's really impressive that the increase, and it gives hopes to the region, because it's true then if we go to Angola and Mozambique, which are the two countries with more representation, we see still a low number of parties involved in ICC arbitration. And I have some comments in this regard, because then we see the importance of the place of arbitration, and we know how important it is to have the place of arbitration in the countries, and the importance of that to the arbitral proceedings. And we see that we have very low places of arbitration, and it's a combined effort, right? If you have more parties, you have eventually more places of arbitration, you have more arbitrators, you have, and it's that we need all, and that it's an interesting assessment of the Queen Mary survey, that the need of increasing diversity in terms of geography and ethic as well. So I think here it's just a curious element is that, for instance, Maputo in 2020 was fixed by the court as the place of arbitration. Angola, unfortunately, it's wherever we didn't have any in 2020, but we did have in the past 2 years 2 and 1, and Portugal again increasing. Here, I think it's important to consider, of course, also the support of the state courts to arbitration, and it's something that eventually Guilherme may wish to discuss, because there is a recent trend in Brazil that needs to be analyzed carefully. In terms of arbitrators' nationalities, again, I think it goes without saying that the countries that have more parties have more arbitrators, so Brazil and Portugal. We have been seeing recently a good number of Portuguese arbitrators involved in international disputes that are unrelated with Portugal. And with Brazil, less so. I think we still see Brazilian arbitrators acting more in domestic disputes, and that's because of the importance of the markets that we already saw before. Here, I would like to do just an overview, and Gustavo was the first counsel of our team in Brazil that we opened in 2017. And it has been also an extremely successful office. So far we have registered already more than 100 cases. A very important element that I mentioned before is the importance of the participation of the states and the state entities in ICC arbitration. We have 31 ongoing cases with 38 state entities. There you can see the aggregated amount in dispute, which is quite relevant, and the main sectors: construction, transportation, services, and agribusiness, which I think it's quite similar to what we see in Africa: infrastructure, energy, oil and gas, of course, and telecommunications as well. What I would like also to mention is just the efforts, because one may wonder, what is the ICC doing in order to increase the footprints in Africa, and also included in of course, Lusophone countries. And we do have an African Commission that has been quite active and took advantages of the pandemic to also try to organize events that would be more inclusive, and we even organized one in Portuguese. We do have recently appointed an Africa director, a regional director for the region. Unfortunately, she doesn't, Yamana Diawara, she doesn't speak Portuguese, but she's very willing to learn and very willing to organize things also with the local community in the Portuguese countries. And the words of also, I think we are quite proud of the Queen Mary survey results that for the region, both for Africa and for LatAm, clearly gave predominance to the ICC in Africa with 79% and to LatAm with 87%. So I think this needs to be something that we all need to do together with the arbitral community in order to increase presence, to increase trainings, to bring state courts together to our discussions, and hopefully to see Brazil as it was 20 years ago. Hopefully in 20 years we will be in the same position.
Thank you, Anna. I think you gave us a nice segue, perhaps to hand over the floor to Guilherme so he can explain how the 25-year-old chap is doing. I know you have interesting comments and realistic criticism to make.
Sure, Luis. Well, thank you very much for the invitation. And just like Anna, I would love to be there in London with all of you. In fact, I would trade my glass of champagne for a pint of Camden House and a couple with a match of West Ham. But since that's not possible, we're here, and thank you very much for this opportunity. I like to think of Brazilian modern arbitration as a person. So she was born in 1996 with the enactment of arbitration law. She learned how to walk in 2001 when the Supreme Court decided that the Arbitration Act was constitutional. And we took this kid for her first trip abroad within the ratification of the New York Convention in 2002. So since then, the arbitral community in Brazil has nurtured this child very intensely. So any attack on arbitration, on the tenets of arbitration, was met with fury by us, by the arbitral community. And we had in the judiciary a great partner in that endeavor. So the Brazilian judiciary has in fact embraced the cornerstones of arbitration: separability of the arbitral clause, competence, the finality of arbitral awards. All those cornerstones were actually encamped and supported by the judiciary. And the result of this makes us very, very proud. So that beloved child, arbitration, Brazilian modern arbitration, can now be considered as a grown-up, as a young adult at least. And we have a well-developed arbitration market in Brazil, great professionals. We have excellent domestic arbitration centers. We have an arbitration-friendly jurisdiction, no doubt about it. Arbitration has expanded to state entities, the public sector, has expanded to labor claims as well. Brazil ranked second in the ICC with most parties in procedures in 2020, as Anna just mentioned. And Brazil is also home to an ICC office in São Paulo, which is no small feat, as Anna can attest to us all. So all of this paints a very beautiful picture, and it really makes us proud. But in recent times, however, it is fair to say that we can identify a turn of the tide in Brazil, especially when it comes to case law arising from state courts. Just to give you an example, I don't have all the numbers to present to you, but there is a strong feeling in the arbitral community that the number of cases in which arbitral awards have been set aside, or at least had the enforcement state, has apparently grown in Brazil. The reasoning of these decisions varies a lot. It varies from lack of disclosure from an arbitrator and conflict of interest that arises, up until, in some extreme instances, a revision or a partial revisions of the merits of the decision, even though disguised as a violation of due process. Some of these cases have attracted a lot of public attention. For example, the Eldorado arbitration, the Petrobras arbitration. For different reasons, I'm not allowed to comment on, to elaborate on those cases. But suffice to say that the reason why some of these cases are being brought to public attention is also a reason that worries the arbitral community. And it has a relationship with the provisions of our statute or procedural statute that provide that arbitration court cases related to arbitration must remain sealed when the arbitration was confidential. We have a specific provision in the Code of Civil Procedure in Brazil stating that. But courts in São Paulo have consistently lifted those seals from these cases through the reason for this decision is that the provision of the Brazilian Code of Civil Procedure would be unconstitutional. So this, of course, brings some worries to the arbitral community, because you see that the judiciary begins to question some of the provisions that we were very used to for quite some time. And all this new scenario, Luis, really has brought some people to ask, and a lot of people actually to ask, whether arbitration is under attack in Brazil. But I have to tell you, I really don't think so. I really don't think that arbitration is under attack in Brazil, not by the community, not by the courts. And coming back to my previous metaphor, just as holding an adult person accountable for her actions cannot be considered an attack per se. On the contrary, it's only natural to do so. To demand from arbitration an adequate answer for dispute resolution and holding arbitration accountable for its shortcomings is also natural. And it also cannot be considered as an attack. We have to realize that today, in 2021, arbitration represents to businesses in Brazil much, much more than it did 25 years ago. The expectations are much higher, and consequently, the standards by which arbitration will be judged and evaluated and criticized, these standards will also be higher. And in other words, and as you mentioned in your opening statement when you introduced me, we must recognize that arbitration has achieved its adulthood in Brazil, and we must therefore accept responsibility for its shortcomings and use these shifts in case law as a warning and an opportunity for auto-criticism, which is very important for human beings and is very important for human-created institutes. Of course, there are excesses and mistakes in courts' intervention in arbitration, but not all court intervention in arbitration can be considered an excess or necessarily wrong. And this statement is not only true to Brazil, it is true to any other country in which arbitration has been well developed. So going into specifics of this situation, I think that Brazil has got to rise to the challenge of coping with this new reality. We cannot treat arbitration as a spoiled kid anymore. We cannot protect it anymore from this criticism. We have to address this criticism in a responsive way. And to sum it up, I would like to mention a few of the challenges that I think we have to face immediately if we want arbitration to keep growing as it is up until now. First of all, we must widen the pool of arbitrators and avoid repetitive appointments. This is one of the reasons why we have so many challenges to arbitrators in Brazil based on conflict of interest, and also delays in arbitral proceedings, given the fact that some arbitrators have like 40, 50, 60 cases ongoing, and this is only not sustainable. It's just not sustainable. The second thing, we need more transparency in the selection of arbitrators and clear standards on the arbitrator's duty to disclose. This duty to disclose must be put under a scope and really analyzed, and the criteria for disclosure should be more detailed in Brazil. Mm-hmm. Third, but not less important, I think it's even more important, we must promote diversity in arbitration. And I am not referring only to gender diversity. I think we have evolved a lot in that area, and I believe we are in the right path. But I mean especially racial diversity, which, to be absolutely candid with you, is in such a low level in Brazil that it borders the unacceptable, especially given the origins of our population. So I don't think it's acceptable anymore that we hide this problem. We need to address it in headway. We also need to worry about data protection. Courts in Brazil, state courts, are being hacked as we speak. So arbitral institutions must also be careful in the way they deal with data, and they protect data from arbitral procedures. And not only institutions, but also law firms, arbitrators, and so forth, experts. More practitioners, be them arbitrators, counsel, experts, they should be more familiarized with the new technologies and use them to conduct proceedings in a more effective way. I've witnessed and participated of lots of different hearings during this COVID crisis, and it's astounding to see the discrepancies among these practitioners when they deal with new technology. Some of them simply do not know how to deal with it, and we must address that problem because this is the new normal. I don't like that expression, but I have to use it in this context, and we have to get used to it. And so to conclude, I am an enthusiast of Brazilian arbitration. I've always been an enthusiast, but since we are virtually in London, I have to quote Sir Winston Churchill: "No one pretends that arbitration is perfect or all wise. Indeed, it has been said that arbitration is the worst form of dispute resolution, except all the other forms that have been tried from time to time." So this is the message I have to you. But it's time, however, for this grown-up to leave its parents' home. Thank you.
Thank you, Guilherme. I think it's obviously a good comparison, and there are some new kids on the block, and Itueva is, it's part of the movement, and I'm sure some of the examples will set the scene for what's going on in Africa. This huge growth in Angola and Mozambique, and Itueva is going to talk to us a little bit about Itueva on the what you think are the key recent developments that someone sitting in London or in Brazil or elsewhere should be aware of in relation to Angolan arbitration. And you unmute yourself, please.
Yes, thank you so much, Luis. Well, one of the things following up on Guilherme is that Guilherme has been talking about the age, as an adult, arbitration in Brazil being an adult. So here in Angola, we just reached 18 years. So we are young adults with a little bit of, I think none of responsibility, thinking that we know already a lot of things, but we are still in the middle of the way. Of course, that's having a law for 18 years. So our law was approved in 2003. But having little or few arbitrations, it's complicated because you see, it's a long time, and from the statistics that Anna showed, we should be further. You know, we should be much more advanced, especially because there is a connection between Angola, Brazil, and Portugal. You know, a lot of law students, I believe that the majority of law students that are here, Angolan law students or graduates, they studied in three main places. One is Angola, the universities in Angola. The other parts, the majority that has financial possibilities or find a way to go outside, they choose between, the majority, they choose Portugal, and then they choose Brazil. So we don't see many people related to law trying to study in the UK or in Paris, maybe just for LLMs, for post-graduations. But for the basics, our main relationship is with Portugal and Brazil. So we should be in a better position, especially because of the connections that we have. We have a lot of foreign councils operating in Angola, a lot of connections with especially Portugal, and not so much Brazil, but because of the legislation, which is very similar. In some cases, it's still we are still using the civil code from the colonial era. So there are a lot of similarities, and of course, this shows us that we should be much further than where we are. So having the Arbitration Act is very positive, but still comparing with numbers, when we see with numbers, it's not very good. But one of the recent developments that we had was the signature of the New York Convention. This grants more confidence to investors, especially those that are even, it doesn't matter if they are discussing or they are having a dispute outside of Angola, but if the assets are in Angola, they have some kind of assurance. I'm actually working now on a study. It's taking a little bit longer, but I'm working now on a self-study to understand how many foreign awards, arbitration awards, were accepted in Angola, how many went to the Supreme Court, and how they are being implemented in Angola. So I'm really curious about that. Yes, I'm looking forward to share it at least until the end of the year. So I'm pushing a lot for that. So this is of course, this is a great step for us. It gives confidence, as I said, to investors, or anyone that is connecting or trading with Angola, of course. I can say that I can only identify the development, but in terms that there is the other side, the challenges that we have. For instance, one of it is this one, because our Supreme Court webpage is public, but if you try to research, you don't find anything around it. Even the so famous constitutional decision around the possibility of foreign councils acting as councils in arbitrations in where the place of arbitration is Angola, it is a problem. Everyone says that the tribunal constitution accepted that, but it's so difficult to find, that report or that decision. And
it's a good sign of support to arbitration, you think, overall?
Well, it should be, but we have a very protectionist legal system here, especially because, well, we can be considered young lawyers, not just me, but even the senior lawyers and partners in our markets, compared to law in Portugal and other countries. So it is, in some sense, it is a sign of support for the arbitration. But on the other side, when you have an arbitration act that specifically says that can only be a council who is authorized to work as a lawyer in Angola, you can see that there is not that much support, because it's clear that you can only act as a lawyer in Angola if you are registered in the Angola Bar Association. So this is really difficult, but still now when you ask, for recommendations of local arbitrators, unfortunately, we can only find 2 or 3 names. So this is how, or they are not very well known. But of course, if the market is arbitration friendly, we should know more people, more arbitrators, more counsels working in arbitration. So this is really a difficulty. So we don't have a lack of support per se. We have a Center for Resolution, for Disputes Resolution, which is called CREL. But even that, CREL was constituted, I think, in 2016, but the regulation was only in 2018. So there is a lot of time between the act and the implementation, or in the regulation, which put us a little bit behind. But of course, that's we are now more aware of it. A lot of people is more interested on it. But as I think that it was what Guilherme was saying, we need to give opportunity to these adults, to act and to be accountable for its acts. There is still a lot of sense that judicial is better, although it's not, but the pledge in the judicial institutions, it's better, it's more exciting and everything. And of course, you don't have the same, you can't have the same type of behavior in a court and in a tribunal. And that's what Guilherme was saying, you can see the way that the behaviors, and they are very, very different. So we still have a lot to do. We still have a long way to go, but we can see the movement growing, yeah.
No, thank you, Tova. It's good. That's exactly how I feel. I think I gave a lecture with Anna, several summers ago, pre-COVID, and we thought we went to University Agostinho Neto, and it looked empty, and we thought, oh, no one is coming. We're going to be here by ourselves, etc. And we get into the auditorium. Apparently, the entire university was inside the auditorium. That's why it was so quiet outside. So it was, and we spent there's so many questions. So there's huge interest, and I think that's the vibe that I felt 15 years ago in Brazil, and I'm sure there's all the interest will follow. But just not forgetting that we have Frederico here. I wanted to give Frederico the chance to comment on his fantastic and career as a barrister, which is not something you see in Lusophone jurisdictions, and how that's useful for Lusophone disputes. Frederico.
Thanks, Luis. Thanks, Luis and Carlos, for the invitation, and special thanks from me and my business development team at Hardwicke for the introduction that you both gave me, which was very flattering. So yeah, being a barrister in Lusophone jurisdictions is certainly not a common occurrence from my experience. So as far as challenges go, the first challenge is actually to explain exactly what it is barrister is and what a barrister does, and how a barrister may be able to assist in international arbitrations, either as counsel or indeed as arbitrator. Once parties, lawyers in Lusophone jurisdictions, once I can get over that hurdle, then and I get into the business of arbitrating, which is what I've been able to do over the last few years, then I would say, from my personal perspective of a person who was qualified in England, and I suppose because we're in LIDW, this is probably of interest to the audience, but from an English perspective, going into Lusophone jurisdictions, I suppose the three main challenges that I've experienced are threefold. First, the legal challenge, secondly, a procedural challenge, and then thirdly, a cultural challenge. So In terms of legal challenges, I suppose there is this age-old debate about the divide between civil and common law jurisdictions. Of course, I'm trained in common law, and the lex causa, or the applicable law, tends to be the local law, which tends to be civil law. As Anna said, pointed out in her slides, there are a lot of Brazilian arbitrations are domestic, or at least quasi-domestic. So they may well have a seat of an arbitration abroad, or they may have English language applicable, but they are effectively represented by Brazilian lawyers. They have Brazilian law applicable, often because these big energy infrastructure disputes are with public entities, and therefore by their legislative nature, Brazilian law may apply, or Angolan law, or the law of Mozambique. So you get issues that are specific to maybe the differences between common and civil law. For example, something which has been topical because of COVID is force majeure. Is in civil law jurisdictions, it tends to be inherent in the legal system, maybe part of the civil code. Whilst in the common law, you'd have it specifically agreed in a contract, and it'll only be available to that extent, and you have to determine scope. Another concept which legally will be different to common and civil law is, for example, the concept of privity. So, for example, in an infrastructure dispute, you may have concurrent liabilities, contractual and tortious, and you have to determine whether or not there is concurrent liability in that particular jurisdiction, or whether there is a non-communal principle, such as in French law. I'm sure that Louise will be able to pronounce that much better given his stint in Paris. Turning then to the procedural differences. So I mean, not only do we have the framework of the lex arbitri and maybe the local institutional rules, which might be unfamiliar, but also practical differences. Things like, I'm always taken aback, with the limitations we have in the high courts, the English courts, about the length of memorials in Brazilian, Angolan, Mozambique memorials, and also the volume. We normally have 3 rounds in England. You have a claim, a defense and counterclaim, and a reply. But memorials can go on tenfold in civil jurisdictions, and just getting to grips with the volume of information and actually getting to the issues to identify can be a challenge. And also a peculiarity, for example, in Brazil, about the role of experts. Experts tend to be, in England and in a lot of the world, independent parties who are there to advise the tribunal or assist the tribunal. In Brazil, in particular, only tribunal appointed experts are independent. Party appointed experts owe a duty to act in the best interests of their instructing party, which is quite unusual. And then finally, in terms of cultural differences, and specifically to my experience as an arbitrator, I see notable differences as things like the culture of interviewing arbitrators before appointment. This is something that I see is increasing in Brazil, but isn't historically something that necessarily will have happened. And as Guilherme put earlier, the issue about disclosure, I think in America, probably people over disclose, and that's a running theme I've heard over this week. I think in certain jurisdictions where there is a small arbitral community and everyone knows each other, then perhaps there might be a tendency to under-disclose, or certainly to presume that the parties simply know. And in England, I would probably say this being biased, and I admit my potential bias, but I think we're probably in the Goldilocks zone of disclosure, and we probably give just the right amount. So, an English barrister might not be an obvious choice to act as an arbitrator in Lusophone disputes. All the things that Guilherme put at the end of what he said, those factors that Brazil is looking actively to change, the diversity, the conflicts, etc. I have probably found myself in a sweet spot where I was born and bred up till a very young age in Brazil, and then came to England and qualified here. So I've retained sufficient Brazilianness and enough Portuguese to be able to handle, a hearing in Portuguese. But I'm qualified in common law, so I think like a common lawyer, and also as a barrister. And I benefit from the reputation of the bar of independence and excellence. And I think having the familiarity of the system, not just the language, but actually, how the land lies in these jurisdictions, the local problems, has allowed me to be in this privileged position of sitting in a number of arbitrations in Brazil and in Lusophone jurisdictions. And I suspect that my lack of conflicts also doesn't hurt at all.
It doesn't.
So
it doesn't.
back over to you.
Especially in these times, I must confess, culturally, it was a big change. The first hearing I did here, I had barristers, arbitrators, opposite counsel, and people, and there's this sort of sequence of comments where I say, okay, what we're going to do? Oh, we're going to do this in the usual way. Oh, the usual way. Oh, works great. Okay, let's do it the usual way. And I was like, and I had no idea what they're planning, but I grew a big fan, especially of filings at 5 p.m., which is great. But just, we have a few questions. And one from Pacomi Ziegler to Itueva. Obviously, the limitations to foreign practitioners raises concern. And Pacomi asked the following question. Has the Angolan Prosecutor's Office a record of acting upon alleged infringements of Angolan law in that regard? Are you familiar with this, Itueva?
Unfortunately, I'm not familiar with it. I know that with Angolan lawyers, we tend to use that weapon, maybe to try to impose some kind of respect when it's difficult to have a colleague from another jurisdiction being polite to us. Because it is, unfortunately, it is another struggle that some of us have here. Like, okay, you are in Angola, you are useful to go to the institutions, to hand over documents, you are useful to be in a table of negotiations with an oil and gas, an operator, an oil and gas company, but you are not allowed to open your mouth, you are not allowed to give your opinion, you are not allowed to give the strong's view that you have about the local laws. And this creates some kind of struggle, and that's why even it's not just the Angolan Bar Association that has created the laws or approved the laws, has in place the laws of protectionism of Angolan lawyers. Lawyers itself, they try to connect with lawyers of other jurisdictions, but things not always go very well. So I understand that this is a weapon that is very used, but I'm not aware of anything in the prosecutor office.
So it seems to be popular. Just remind everybody, we do have a Q&A, toggle there. So if you want to ask questions, you can do through the Q&A button. So another question for you from Colin Johnson, asking, is the role of the experts in Angola similar to the one that we see in Brazil, more of a assisting técnico that we called, rather than use it a tribunal's expert? How is that works in Angola? Hopefully I made justice to your question to Colin.
Well, especially when you have ad hoc arbitrations, where the rules are agreed, and are created for that specific tribunal, the appointments of experts, it's the regular use. But I would need to check. I don't want to speak just by mind. But they are not considered technical assistants. No, they are experts and they are respected as experts.
Perfect. Thanks, Itueva. Anna, can I come back to you? I saw in your slides, you see Macau there. I know there's something that close to Guilherme's heart as well. can you give us some insight of how you see Timor and Macau coming to the ICC map?
Yeah, you saw the figures, right? It's still really low. We have been working in the past with the Asian Development Bank in some initiatives to try to foster arbitration in both places, but definitely it's something that I think we need to work even more than with Africa. But with Africa, we do have some already consolidated initiatives, and I do believe it's a matter of time. With these two jurisdictions, I think we need more efforts than this isolated initiatives, Luis. But unfortunately, at this stage, I think that with the importance of Asian, that became very, very clear in the Queen Mary survey, not only in terms of the importance of Singapore as place of arbitration, of SIAC as an arbitral institution, and also the importance of the 50% of the responding parties were from Asia. I think there is potential for sure to make it maybe even a hub for arbitration between Portuguese speaking countries and other Asian countries. But we need to set up our strategy in more clear terms. I know that our regional director has been also involved in these initiatives with the Asian Development Bank. We have our Belt and Roads Commission as well involved, and I know Guilherme, you may have some comments in that regard, but it's something that I was thinking when I was preparing the conference that deserves more attention.
Luis, Luis, sorry,
sure.
Can I just ask a follow-up question? And I also saw, and you mentioned that Portugal had an incredible development, I think proportionally even bigger than Brazil. What's the reason for that? What happened in recent times in Portugal that created such an amazing development?
It's always difficult to say, right? I think we have been more present, and I don't want to say that it's because I'm Portuguese, but I think we, with the National Committee in Portugal, we have definitely been more active, more present. And this is clear in market that, when you have local presence, even though you are a global institution, that has results. It may take time, but it has ultimately results. Maybe that's one of the reasons. I think, again, it goes back to also growing the importance of international arbitration, right? Portugal, probably for domestic disputes, they go more. It's not like Brazil that we do have 30% of domestic disputes coming to the ICC, right? In Portugal, you see more the truly international disputes as you see in Angola and Mozambique. It's completely different, the nature of those disputes. But I think that by growing the importance of international arbitration, by also demonstrating what is the difference of having an ICC arbitration, because one tends to think it's much more expensive than others. Why would we go there? And it takes time to explain, and it takes time to change the concept that it's more expensive, therefore it's excluded. So I think we have been doing that work. They have been having more foreign investment in the country, so therefore more international disputes, more Portuguese arbitrators acting internationally. So I think it's a combination of factors. And probably it was also a country that had a lot of ad hoc arbitrations. So I think we are conquering part of that market. This is my personal opinion. It's always very difficult to point out to the reason. I think it's a combination of.
Yeah. Well, there's one factor I think that's very important. I think Portuguese arbitrators are just the average is excellent. The education is fabulous, and they are out there. They are in ICSID panels. They're very international, and there's something in the blood. They had half of the world at some stage, and I'm sure that will come into arbitrations as well. And obviously, there's the size of the economy has an impact on that, and as the arbitrators become more international, you're going to see more, I think, Portuguese arbitrators abroad. And there was one question from Stacey Tretton, if I'm not mistaken the name, on recoverability of awards. So I thought I should ask Guilherme about that, because one of the discussions that we have often with clients when opting for Brazil seat is that the seat is very good, notwithstanding the issues that you raised, but obviously choosing a seat abroad has the recognition and enforcement challenge that's taking quite a long time. So can you comment on that, Guilherme?
Yeah, I think it all depends on the profile of the parties. I mean, if the potential debtor has a profile of questioning decisions, of trying to raise challenges all the time, it wouldn't be very smart to choose a seat abroad, because we have a very, as I've mentioned before, have a very strong and arbitration-friendly jurisdiction in Brazil. We have an ICC office in Brazil, which suffices to say you can have an international arbitration seated in Brazil with absolutely no problem regarding the institution or the practitioners. So if you have any questions about the intention of the potential debtor in your case, and this debtor has assets, its main assets in Brazil, you should opt for the seat in Brazil. I wouldn't opt for a seat overseas, because of course, it's not just a case of Brazil, but any country. If you have to enforce a foreign award, it's one more step you have to take. And if you have the arbitration here in Brazil, you already have accomplished this step and just right in front of the goal. So that's why I think that you will better choose a seat in Brazil. But of course, there are some clients that have some concerns about the neutrality of courts. I really don't think it's such a heavy issue in Brazil, such a pressing issue, but I respect these clients' decisions sometimes to have arbitration seated outside Brazil. But I wouldn't recommend that in most cases.
Thank you, Guilherme. We have a question about from Sergio Yaguiar, a good friend, about looking at the Queen Mary survey, why London is not a favorite seat for Latin America. Indeed, doesn't appear among the top 5. I was at Whiting case, and there's obviously an element of on the research on who is responding, who's giving more responses, and I think that's a very good question, because obviously historically, Latin America will look a lot to New York, Miami, etc. But I think this meeting is about a change. It's about giving clients a service. And when you think about Asian, Indian, European clients, if they can, they don't need to go to the US, and some of them won't want to go to the US. They might want to have hearings close to home, rather than having dispute in Latin America or in New York when they invest in Latin America. So I think what this meeting shows is that there is capability, there's a bar that's sophisticated that can handle those cases here. So what we need to do is those who are in Latin America and prefer London, be more active in responding. But anyway, so I wanted to give the floor to you to comment on that. I don't know if you have any insights, or to Eva, or
if I may, Luis, yes, because I think it's interesting. And you in Mayor Brown with Gustavo, you organized an event on arbitrating Brazilian disputes in the US, right? And at that time I had the opportunity to dig in. And I really think, Latin America, as I mentioned, is mainly influenced by Brazil, because at least in an ICC context, as I said before, it represents 40%. So again, it goes back to what I said before, mainly the places of arbitrations are in Brazil. And when they need to be abroad, you're completely right. I think users go more to New York or Miami, or eventually, and I don't want to praise the ICC, but I think it's not that rare that they come to Paris, because the ICC is in Paris. So I do think that London, if it was chosen before, it's true that it's losing to this three cities. And I think that's what I wanted to basically to mention.
Louise,
sorry, just one thing is that I think something that I found extremely interesting. I went through all cases with Mozambique and Angola, and all of them, I would say that there is a trend for Angola to go to Switzerland and a trend for Mozambique to go to London. And this is the main, I think the main trend that I saw in terms of places of arbitration, which I thought it was very interesting. And therefore the law applicable to the merits follow most of the times the place of arbitration and the constitution of the arbitral tribunal.
And just on that, it's possibly because Angola has a lot of Chinese investors, and they like Swiss law, and then you get that connection. And Mozambique is a part of the Commonwealth. So
Commonwealth.
And I think and Angola is I think is applying or in the process of applying. So anyway, sorry. I think Frederico, you had a comment, and we probably running out of time already. So I want to give you the floor.
Thanks, Louise. I just wanted to add to that, really. I mean, I've been banging on about Latin America for pretty much the entirety of my career. And I'm pretty sure when I started off, we wouldn't be able to hold an event such as this because there just wouldn't be sufficient critical mass of interest. I'd say that the reason why there has been growing interest both ways is predominantly because of the interest that London has shown towards Latin America. I think historically there was a little ambivalence. London was more interested or more focused on perhaps China, Russia, the Middle East, and other jurisdictions, the Commonwealth and the US. And Latin America, for Portuguese and Spanish and other reasons, was simply an undiscovered country, together with a lot of Africa. That has changed over the years. And also, I think there is now, we can see from this event, enough Latin Americans in London practicing so that you can offer the services to Latin American clients, whether it be an understanding of their own legal system, whether it be a linguistic issue, or anything else. So it's a combination of things, I think, but you know, I think we're still quite a way away from maybe the connection that somewhere like New York or Washington or Miami has. You're absolutely right. I think New York and US investment has also always traditionally gone to Latin America and Brazil. But now that we see places like China and APAC region investing more heavily in Latin America, it's very often that parties from either of those want to choose a neutral venue. And London is becoming an option. The other issue why I think maybe Paris might be preferred, or indeed Geneva, is common law versus civil law. I think there is just a familiarity with a civil law system that perhaps you don't get with London. But that aside, I think there are some issues where common law and English law in particular have been a strength, like insurance and construction law, maritime law in particular. And we've seen those arbitrations come to London, but it's just about building on that, I think. Thanks.
Thank you. Look, I think we're probably about time, Brazil time,
yes,
so
we
5
are.
minutes late. So I'd like to hand over to Carlos for any final comments.
Yes, no, just adding to what Frederico says, and maybe we in this panel, we have something a little bit to do with it as well. Maybe we are managing to shift this towards London a little bit, right? But well, I think that's it. Very interesting discussion, very interesting points. Unfortunately, we cannot go over time because this is England and we have to finish. So thank you very much to all of you. Guilherme, Ana, Frederico, Itueva, and Luis, thank you so much for partnering up with us on this. And thank you to LIDW and everyone that made not just this event possible, but also the whole week, which has been quite interesting. And I recommend that if you haven't done so, that you attend the networking sessions and all the sessions that will happen tomorrow. It's been quite interesting. But thank you very much and have a good evening from London. Bye-bye.
Thank you, everybody. Bye-bye.
Bye-bye.
Thank you.